Yeah. Am I visible? Siddharth, am I visible?
Yes, yes, yes.
Yeah. So good afternoon to all, and welcome to this webinar on intellectual property rights and its significance. We are organizing this webinar especially because today is a World Intellectual Property Day, April the 26th. This is the day which was the WIPO, World Intellectual Property Organization Convention. They actually designated the 26th of April as the IP Day, World IP Day. So as part of that, we are today organizing this webinar to highlight on the significance of intellectual property rights, how it is beneficial for the MSMEs and startups. And we have with us experts from this field. We have with us Mr. Sandar Bhattacharya, who is Deputy Controller of Patents, Ministry of Commerce and Industries. Sir has been always associated with us for a long time, and he has always been a mentor for us. Then we will be having Mr. Devanjan Chakraborty, Head of Office, Patents Office, Calcutta. And we have with us Mr. P.K. Bakshi, who is a designated attorney of the Indian Chamber of Commerce Intellectual Property Facilitation Center. We have also with us Dr. Sohini Banerjee, Associate Professor from Indian Institute of Social Welfare and Business Management, Kolkata. And we have Dr. with us, we'll be joined by Dr. Topi Basar, who's the Associate Professor. She's already there with us. She's the Associate Professor from National Law University, Guwahati, National Law University and Judicial Academy, Guwahati. So to start with, I'd like to begin with, first of all, welcome all the dignitaries, the speakers for their time, for being here. So I'd like to start with Mr. P.K. Bakshi, I'd like to request you to kindly address the audience and deliver the theme address of this webinar.
Good afternoon, everyone, and I welcome all on this auspicious occasion of World Intellectual Property Day, and I welcome you all in this August house of organizing this webinar by Indian Chamber of Commerce. And basically the purpose of today's webinar is to discuss about the revival strategy of the economy of India through the startups and MSMEs, then ways and means to enable the IPR requirements of startups, MSMEs, and enabling sustenance in the market, and survival strategy of the startups, MSMEs, utilizing IPR as a tool. Well, to start up with, that the revival strategy of the economy of India through startups and MSMEs are very important, because as far as my observation concerned, during last few years, we have seen that the present government is putting all efforts to strengthen the MSME sector, because that is the MSME sector is the largest sector of entrepreneurs and enterprises in India, who generates the maximum volume of taxes. And by strengthening this particular sector, will automatically give some appreciable participation in the GDP of our country as well, and also give us our economy a more strengthened manner. Regarding this intellectual property rights, if I'll say that IP tool is the main key tool for the MSME sector to strengthen the economy. Obviously, as we all know, that intellectual property rights is the key factor of strengthening the economy of the country. Because with the help of intellectual property rights, any invention or innovations shall get the legal rights to earn its monopoly in the commercial sector, whether it is in the domestic market or it may be in the international market for export promotion purposes. So India can earn a good volume of foreign money, which will automatically strengthen the reserve of our foreign economy. So considering that, the IPR tool can enable us to strengthen the economy of the country through the MSME sector, obviously. And in most of the cases, we have seen that small invention or innovative ideas can create a large volume of entrepreneurial development in the commercial market, which automatically give a big boost in the field of MSME sector, in the field of other startup enterprises, and entrepreneurs will get more upliftment in the economical progress, and must have a sustainable market, sustainable future too. And for the startups and MSME, by utilizing the IPR only, they can get a more sustainable, they can create, or they can plan a more sustainable survival strategy for the economy of the country, for the economy of themselves, so as to generate more revenue, so as to generate more employment. And obviously, by the help of intellectual property rights only, the research and innovations can get its actual value in the market. And obviously, when the revenue generation comes with the idea of profit maximization, IP is the only tool, I believe, which can give appreciable boost towards the sustainable future of the startups and the MSME sectors. So not only in the field of trademarking, copywriting, etc., but also the maximum boost up can be seen in the field of invention and innovative ideas, where the patent shall give us the maximum boost, I believe, which ultimately gives a sustainable future to the entire MSME sector. Over to Mr. Majumdar, please.
Yeah, thank you, Mr. Bakshi, for the theme address. We now move on to, we have with us a very senior person of the Patent Office, Kolkata Ministry of Commerce and Industry, Mr. Sanjay Bhattacharya. Sanjay Bhattacharya is the Deputy Controller of Patents and Designs. So we welcome you, and we request you to kindly address the gathering and enlighten us with your views. Thank you.
Thank you, Mr. Majumdar, for giving me the opportunity to speak on the occasion of World IP Day. And actually, this World IP Day started in year 2000 with the initiative of WIPO member states. And why it has been scheduled on April 26th, the reason is that on that particular date on which the convention established that WIPO in the year 1970. And that's why every year from 2000 onwards, World IP Day is celebrated, and on 26th April, and we just remember and encourage the people who have contributed in the field of IP. And it is basically to honor our innovators who are very much important for advancement of science and technology, and also in the field of different creativity in the field of copyright law. So it started in the year 2000, and every year we are having a special theme. Now this year stress has been given in for SME, and initially when in 2001 when it was started, and there was, in that particular year, theme was creating the future today. And subsequently in 2015 it is Get Up, Stand Up for Music, that stress was given for music industry. And in 2016 it is digital creativity, and in 2017 it is innovation, and in 2018 it is stress was given for women innovators and on creativity. And now this year it is for SMEs. Now, why this? What is the why stress has been given to SMEs? Now you see that in general we IPR SMEs are backbone of the development, industrial development, because they are having a huge share, and especially that creation of IP is important, as well as protection of that IP is also equally important, because if it is not properly protected, then they may not get the benefit out of their IP creation. So it is vital to protect those natural talent of SMEs and other startups, so that they can contribute to the well-being of the world. And without that appropriate sanctions against infringement or copying, the growth of the thinker and the development of the institution is threatened. So it is very important for the SMEs and startups and other small entities to just go for their IP protection. And it is for that purpose, this kind of program is having a very crucial role to play. Now, people, SMEs, more and more awareness should propagate to the level of that startup companies and SMEs, so that they are aware how to protect their IP rights. And there are some benefits which is provided by Government of India for the startups, particularly for the startups, for protecting their IP rights in the field of trademark, design, as well as patent. And for that purpose, Government of India has developed a scheme of, and under which facilitators they give assistance in filing to disposal of that IP application before Indian IP office, and free of cost to the startup. And their financial part is taken care by Government of India. And initially, there are the two stages that are there. Initially, for filing, they have been rewarded, and after filing, they get their they submit their claim before Patent of IP office, and then it is released. And subsequently, after examination, when that examination report is forwarded to the companies, they are the facilitator on behalf of a particular company. They represent, and they just give the reply and response to that first examination report or subsequent examination report. And after, at the time of final disposal, again, they have been the support which has been provided by the facilitator. They are paid by their expenses borne by the Government of India. So that is a very encouraging action which has been taken by Government of India since 2016. And we are receiving more and more applications from startups. And not only that, another important initiative which has been taken by the Government of India regarding that fee schedule. Initially, we are having three different fee aspects. One is for individual, and second one was for MSMEs, and third one is for legal entity, big companies. Now it has been, there are two types of fee structure. One is for, and in first, along with individuals, MSME and universities, obviously government universities are clubbed together. So for getting IP rights, now fee to be paid before for obtaining IP right is reduced to a great extent for MSME as well as startup. And for legal, it is 1,600 for patent and 8,000 for legal entity. For individuals, it is 16,000. Sorry, I am very sorry. It is 1,600 for individual as well as universities, MSME and SMEs. It is just 1,600, and for legal entities, 8,000. So that is also a encouraging fact for the startup company and as well as SMEs. Now you see that. Now, this ultimate objective is that for the growth of different in the field of science and technology, as well as in different kinds of business, And it is always required that everyone should be encouraged for creating their own IP, and people will be encouraged when people will be encouraged when they are getting proper protection on their IP, and they are getting financial benefit out of that. And now, last year we have passed through a pandemic situation, and this year also it is continuing, and we are in a very difficult situation. And however, still, it is if we go to the facts and figures, that SMEs are make up around 90% of the world's businesses. So their importance is they are very important for the global economy. Now they employ around 70% of the global workforce and generate up to 40% of national income in many emerging economies. So that is why MSMEs are very significant. And at the time when it is imperative for economic recovery under this pandemic situation that World Intellectual Property Day shines a light on the critical role of SMEs in the economy and how they can use this IP right to build stronger, more and competitive and resilient businesses. So SMEs are the backbone of national economies, and they deliver the goods and services we need every day. And they just break through the innovation and inspiring creation, and they create jobs. Some become the world-leading business of tomorrow. And now, and if anyone is new in the world of IP, the world intellectual property of day is an opportunity to find out the tools of the IP system. Now, what are the tools? That is trademark, design, copyright, trade secret, geographical indications, and more. Now, when IP rights, one can turn an idea into business opportunity. It can generate value, create employment, and enrich the choice of the products available to the consumers. And because of that, because of that, the national and regional offices are also having an important role to play. And what facilities we are having in our IP offices? Actually, because of this current situation, we are having before this pandemic situation, we are already having the online facility. And for different IPs, starting from filing to the disposal of particular application, everything is online. And last year we have introduced online hearing facility for design as well as trademark also. For patent, it was already there. So there is no need of visiting our office to just getting a IP protection. So that is a very advantageous situation for the applicant, IP applicant who are interested to obtain IP rights in India. And if we just look into the statistics of year 2021, in case of patent, we have disposed more than 73,000 of we have in 2021 we have issued more than 73,000 first examination report, and disposal of patent application compared to previous year, that is 1920, it has increased. And similarly, in case of design and trademark, we are following the timeline, and within a month we are issuing that examination report for design, and we have issued and maintained that design examination, first examination report in a time frame of 1 month, and finally registration is also taking place in due course. And we are overall, in case of patent, we are our pendency has come down, and if a patent application is patent application is filed before patent office, and that waiting time has reduced in a large extent. And if early publication request is made, then one can expect in normal route that within a year we can he may get the first examination report from the office. And in case of expedited examination, within a year, he can get the patent also in case it is granted. So this is the scenario of this office. It is overall, we are just geared up to build the IP application. Now it is up to the applicant or different Indian companies and universities to show their interest and file more and more application for getting their IP right protected. And with that, I would like to conclude. Thank you.
So thank you, sir. Thank you, Sanjay Bhattacharya, sir, for your words. I hope you will be there. We are getting some questions from some of the attendees. So we will have a quick Q&A session after the deliverance of all the speakers. So please be there, sir. There are some queries which are coming regarding patents.
Okay.
So yeah. Thank you very much. So now we have Mr. Debanjan Chakraborty. There is a technical problem. He's not able to join. We'll resolve that. Prior to that, we have with us Dr. Tuti Basar from Associate Professor at National Law University and Judicial Academy. She has a meeting at 4 o'clock also, she informed. So, madam, if you could provide your deliveries and enlighten the audience here. Thank you. Dr. Topi Basar, are we audible to you? Dr. Topi Basar? Madam, are we audible? We cannot hear your voice so clearly. Madam, if you'd switch off your video, then maybe there might be some bandwidth problem, so we can listen to your audio also. Dr. Tobi Basar, we see you. You are online. I request Debanjan Chakraborty sir to kindly join as the panelist. Yeah, you are there. Fine. Dr. Topi Basar, madam. Can you hear us? Dr. Topi Basar.
Dr. Topi Basar, there is a bandwidth low at your end. Please switch off your video and kindly just talk closely with the mobile. Otherwise, we can hear you.
Hello. Dr. Topi Basar.
Yeah, Pramod, Dr. Topi Basar speaking, but we can hear his voice because there is some bandwidth issue at his end.
Can we resolve it later on? Can we resolve it later on, Debu?
Yeah, you request him to just log off and join, and in the meantime, other speaker can, panelist can carry on this session.
Yes. Yeah, we had Mr. Debanjan Chakraborty. He joined and he again he has disconnected. Debanjan Chakraborty sir, can you hear us? Hello, Mr. Debanjan Chakraborty. Debu, I think there's a massive problem with the network.
No, at my end, it is okay, perfectly.
Debanjan Chakraborty sir. He has switched on his audio, but we are still not hearing him. He has disconnected again.
Because he was speaking and others, just no problem, it's saying at this panel.
So let us come to Dr. Sohini Banerjee. Madam, can you hear us?
I can hear you, sir.
Yeah, Madam, welcome. We would now like request you to resume your start your delivery, Madam. We'll come back to you, to Dr. Topi Basar after this.
Sir, can I present?
Dr. Sohini Banerjee.
Yes, sir. Can you hear me? Am I audible?
So, yeah, you're audible.
Sir, can I present? I seek the permission
Yeah,
of
yeah,
the.
you can share.
I'm seeking the permission of the.
Debu,
eminent-
she can.
Yes, you can share presentation.
You can
I have
share
no-
your presentation.
Thank you, sir. Sir, just a second.
Mr. Debanjan Chakraborty, sir, can you hear us?
Sir, is
We'll
the
come to you
screen?
after this presentation. Yes, madam, please continue.
So, a very good afternoon to the eminent panelists. This is a watershed of a day, World Intellectual Property Day, and this day is celebrated with great fervor, great enthusiasm all across the world. And as our country, India, has a very vibrant intellectual property office and an equally vibrant intellectual property culture, and as Indian Chamber of Commerce is also spearheading a vast movement, a popular movement in IP. So I think that this combination is a very rare one and a very seminal one. And I'm extremely grateful to the eminent panelists to be conducting this wonderful webinar today. Particularly in times of COVID-19, this is just like a breath of fresh air to remind us that there is more to life than an imminent fear of death. So I'm extremely thankful to the wonderful people who organized this. My topic today, sirs, sir and madam, is industrial design and its protection for startups. So I would just attempt to present a few very lucid and a few very relevant points, which is the leitmotif of my topic. Now, in a legal sense, actually, in a legal sense, the leitmotif of industrial designs would be that it constitutes an ornamental aspect of an article. And as we all know that industrial design consists of three-dimensional features, such as the shape of an article, two-dimensional features such as patterns, lines, and color. And in principle, the owner of a registered industrial design or of a design patent has definitely the right to prevent third parties from making, making, selling, importing articles bearing or embodying a design which is a copy or substantially a copy of the protected design when such acts are undertaken for commercial purposes. And further, in most countries, we know that industrial design needs to be registered in order to be protected under industrial design law as a registered design. And internationally, in some countries, industrial designs are also protected under patent law as design patents. And in fact, as you are already aware, there is this WIPO proof service, which provides proof of existence and proof of active use that may be required by these laws to protect the designs. And industrial design laws in some countries, they grant without registration time and scope limited protection, which is to so-called unregistered industrial designs. And depending on the particular national law and the kind of designs that we are talking about, industrial designs can also be protected as works of art under copyright law as well in certain cases. And what's the lex loci? That's what's the legal position in India on industrial designs. Well, as per Indian law under the Design Act of 2000, industrial design protection is a type of intellectual property right that gives the exclusive right to make, to sell, and to use articles that embody the protected design to selected people only. And protection rights, for those who are setting up MSMEs, startups, etc. This is specifically, I'm just telling some rudiments of the subject. That is, protection rights are provided for a period of 10 years, and they can then be renewed once for an additional period of 5 years. And design protection, it provides geography, it does also provide geographical rights as well, like patents and trademarks too. And to obtain design protection in India, the same has to be registered in India as well. So for people setting up startups or MSMEs, the prerequisites of getting an industrial design, that you must know are as follows. Firstly, it should be novel and original. It should be applicable to a functional article. It should be visible on a finished article. It should be non-obvious, and there should be no prior publication or disclosure of the design. Then, the application procedure, which eminent sir talked about. So I'm not going into that. It's fairly simple. The design office has a paper filing system as well as an online filing application. Option as well, and all designs would be categorized as per the Locarno classification for industrial designs, and the filing is done as per the class that pertains to the design in question. And then the application is to be submitted to the design office with the desired designs, a classification code, and a description of the design. Then it goes to through an examination process, after which the applicant receives a communication from the design office regarding any objections, if at all present. And then after rectifying the application based upon the objections, and after responding to the design office, the application is granted if all requirements are cogent and if all requirements are satisfied. And once granted, and if there is no objection from any third-party sources, the design is, exclusive to the owner for the time period mentioned above. Now, just a minute. And the application, after the examination process is completed, the applicant receives a communication from the design office regarding any objections if present. And after any rectification if required, a proper response which is filed to the design office, the application is granted if all requirements are met. And once granted, and if there is no objection from any third-party sources, the design is becomes exclusive to the owner for the time period mentioned. Now, what's the difference between patent protection and industrial design for a person who is setting up an MSME or a person who is setting up a startup? Well, the difference between patent protection and industrial design protection are as follows: that in some cases a question may rise as to which type of protection to opt for, and it's ambiguous as to whether industrial design protection, patent protection, or copyright protection would be more relevant. So I just for visual purposes, I have given a small comparative chart, between patents, industrial designs, and copyrights. So, and it is to be launched before launching the, when to apply? Well, it is to be applied for before launching the product into the market. And there are some definitely some intrinsic differences between both processes. And by the way, why should SMEs and startups look into filing for industrial design? Well, I've tried to give it in my presentation. I've tried to make it friendly to a first-time investor into the culture of industrial designs. Well, as we know that the outer appearance of a product makes it visually more appealing and attractive. And of course, this acts as a value-adding, this is a value-adding aspect, which in turn increases the marketability of the product. And this leads to the need to protect your creation from third parties' use, and in order to prevent them from taking advantage of your rights in this world of competition. And in many cases, the design itself becomes the identity of the brand. And some examples are Coca-Cola's contour bottle, that particular contour, which is that shape, the contours of the iPhone, iPad, iPod, which are quite different. And of course, the shape of distinctive shapes like the Volkswagen Beetle car and the shape of the Mini Cooper car. And what are the key findings for SMEs and startups in India? Well, there is no significant difference. There is no significant difference on paid up capital, employee strength, and firm's age among the startups that file for IPR protection. No distinction is made, and also there is no distinction or discrimination among those who did apply for protection under the IPR umbrella and those who did not. And however, it has been observed in several studies that startups with relatively low paid up capital sometimes show slightly higher propensity to apply for protection of patents and industrial design rights. And a very large proportion today of tech startups, almost 90%, are active in copyright and trademark protection as well as industrial design protection. And we know, of course, that trademarks are the second important aspect of IPR protection. What are the findings for SMEs and startups in India? More than half of the startups, well, they do not have a formal firm level IP policy. So this is where I think the Honorable Indian Chamber of Commerce can be extremely helpful to people who are looking to go into that field. And it is admirable that the ICC, they organize different types of IP training, and in fact SMEs and startups, they do require to organize good IP training for their employees to show them how to conduct IP searches, etc. And particular emphasis should be there in agri-tech, and technology transfer is yet another area where this should be done. And more than half of the startups, they indicated upon a study that they own an IP protection but do not license it, and do not license it to a third party for commercial gain often. And sectoral classifications, they also indicate that firms in e-commerce and technology solutions, such as e-ticketing, Internet of Things, etc., they are more active in licensing out than firms in other sectors. And almost 20% of the startups are supported by incubators, such as IITs, career incubators like Career Launcher, then IISC, as well as the Biotechnology Industry Research Assistance Council, or BIRAC, in India. And although approximately 90% of startups in India today are aware of Startup India initiative of the Indian government, only 35% of them have actually registered under this. And also it has been seen that a mere 20% are aware of the special tax exemptions, specific benefit schemes, etc. And 70% startups, they also believe that conducting awareness campaigns, outreach programs, IP training for students, and establishment of a cell for IPR promotion and management by the government have been helpful in bringing up and managing the startups. However, the most notable hurdles, as pointed out by tech startups in filing IPR applications, are that these are time consuming, these are lengthy, and these are costly. And the average time lag between patent filing and its disposal, whether granted, refused, abandoned, under section 21, is that until 2016, 5 to 7 years, which has now been extremely reduced, as Honorable Sir pointed out. And what are the I would just like to quickly go to some key recommendations for SMEs and startups in India. Well, India needs to take steps to strengthen the judicial protection towards IPR, IPR protection, and there is also a need to establish an optimally resourced and highly efficient judicial system, and possibly the IPAB, if any mechanism can be looked into it, and also, in order to improve the strength, efficiency, and technical abilities of human capital that are involved in the process of IP examination in IP offices, if a more expansive network could be developed, And also international exchange programs are also would be very helpful at this point. And of course, under the SIPP for effective training, as we are all aware, the Honorable CGPDTM, we empanel facilitators to provide free consultation, guidance, and assistance in filing and disposal of IP applications to startups for free. And there also have been very good instances where, there have been reports of facilitators ignoring facilitation to startups and in demanding extra fee from them. And what about key recommendations for SMEs and startups in India? Well, actually, I feel personally that after going through several reports and studies and gathering the experience of several practitioners, that these startups should have all startups should have a proper IP strategy as well as, and the SMEs should have it as well. And this will help the firm compare the cost of IP protection and the benefits which are begotten in the long run. And the firms should also provide staff training on IPR and conduct IP evaluation. And it may also be useful to expand any IP facilitator scope to provide consultations for building IP strategy for startups. And proper enforcement of the initiatives can also make the IP environment of India more robust. And maybe a good, it's just a passing thought, maybe a good national IP action plan that could be very nice in consonance with WIPO perspectives. And in order to build the capacity of SME development institutions and SME finance institutions would be a good idea. And facilitation of SMEs to take part in public funded research and development programs, promotion of research and development activities that respond to the need of SMEs. These would be pretty good. And private sector investment also by using tools of IPRs for protection of innovation and creativity in respect to SMEs, then startups, this would be most welcome. And also to enhance the development of national and international branding strategies of SMEs should also be there. And also to improve access to value-added patent information services, they would also be, for SMEs and IPs, these would also be extremely welcome. And identification and evaluation gaps, definitely these are very good tools for SMEs, resource mobilization, project planning, training the teachers, trainers in SME development institutions, SME finance institutions, SME consultants in the private sector, IP strategy consulting firms, etc. Monitoring and ongoing support, expert missions, online support, evaluation phase, indicators of success, benchmarking, follow-up projects. These would also contribute to the culture. And certain common elements of all national systems of innovation should be there, such as identifying the key industry and business sectors, identification of key universities, research institutes, and other institutional SME and startup stakeholders, strategic coordination, cooperation, a beautiful role by the IP office, a hermeneutic and proactive role of SME development institutions, SME training institutions, SME financing institutions, and greater involvement of WIPO and other international partners, even at the grassroots level, if possible, would be very welcome. And translation and adaptation of content of publications, building the foundations on IP for Business series, IP Panorama, etc. These are good tools which are already there in the WIPO, and let the national stakeholders also use them. Undertaking business-oriented IP education and training, collection of case studies of successful use of IPRs by national SMEs, prioritization of delivery of IPR services to future growth players, such as the startups, such as the SMEs. This would be extremely welcome. Continuous benchmarking, feedback, these are important. Setting up of a single window national steering committee with the eminent officials of the patent office, IP office, that would be extremely welcome. And maybe such a national steering committee would consist of representatives of the government, public sector, the civil society, members of the chambers of commerce, a proper project management, professional project management team, development of a network of contact points of various stakeholders, etc. Then a communication strategy also to approach, to approach any teething troubles, to approach business, the members of the business community, other partners, donors, the public, proper procedures for risk management, budget, financial arrangement. These are very important. And I have tried to give a diagram of some business models. So, we here in this particular graphic, I have tried to demonstrate that sometimes rather than letting one SME, one startup, face all the difficulties and face all the uh, hurdles for getting IP protection for its industrial designs. Maybe if we could go in for a kind of syncretic network between many distributed companies, it could be better. But this is just a passing thought, and I leave it to the eminent panel of speakers who are present and the wonderful audience that we have. A final thank you to the Indian Chamber of Commerce for this wonderful thought-provoking program. Thanks a lot. Thank you.
Thank you, madam. Thank you for your presentation.
Thanks a lot.
Please be there for some time. We have now with us Mr. Debanjan Chakraborty. He is the Senior Examiner of Trademarks, Head of Office, Trademarks Registry, Kolkata. Sir, if you would kindly address the gathering.
Good evening, everyone. Hello, can you hear me?
Yeah, you're audible, sir.
Yeah, thank you. Good evening, everyone. I just wanted to thank everyone for have a healthy and discussion on this IP day. I'll just not take much of a time, and I'll just briefly discuss what the trademark is, and then we can on the question and answers. So, where is the share button, Pranam? I think
Madam,
I am not allowed to share.
Please mute yourself.
I'm trying to.
Madam Sohini Banerjee, please. Yeah.
Pranam, I cannot share my slides. Can you look into it?
Just a second.
Now, yes. I am now a presenter. Okay.
So you are able?
Yes.
So you have to share the screen.
Yes, I am.
Yes, sir, you can share it now, sir. Yeah.
Yeah. Yes. We are seeing it.
Yes. Okay. Yes. Now I'll briefly come into what the trademark is. All of us mostly know, and the role of trademark has a vital implications in MSME and SME, because whenever a new organization or a firm starts a business, the trademark becomes very essential for it to get associated with the brand, whatever it has, and then start investing in it and making a big brand out of it. The on foremost thing, a person, whenever he or she wants to choose a trademark, he can have a look at this pictorial diagram. Trademark is not only limited to words. It can also be any invented words. It can be signature device, the brand name, any combination. It's basically anything what you can actually represent in a piece of paper. Trademark is such a versatile thing. It can be word, shape, slogans, anything, numerals, whatever can be represented on a piece of paper. So these are the like Coca-Cola, the Windows XP diagram is there, the Pepsi there, like the shape of the bottle. Even the shape of the bottle is part of the trademark. The logo of McDonald's the color, even color is part of the trademark. Color of your brand is also becomes part of your trademark, and you can also have a claim in it. How the origin came about is the basic concept of identifying the source of manufacturer. Its importance was recognized only after the Industrial Revolution.
Debu, is there an issue about the audio? Hello, Debu. Is Mr. Chakraborty audible to everybody? Hello.
Yeah, Mr. Chakraborty, please close up your headphone because it is very low sound. Yeah.
He is still not audible.
Hello. Mr. Chakraborty, can you hear us? He was fine previously. Hello.
There may be some setting difficulty in his laptop.
Mr. Chakraborty, kindly check the audio settings because it is not sound is not coming here.
Debanjan Chakraborty, sir, can you hear us? You are not audible currently. You can see your slides. What can be done, Devu? Can from your side can something?
Yeah, he can just switch off his audio and just plug off the jack and then plugging that audio jack. It may be dissolve the issue, I think.
Siddharth.
Siddharth, please kindly call him and just request him to just check his audio.
Siddharth. Please call
Yes.
him. Please give him a call.
Okay, just calling.
Sorry for the attendees and other dignitaries. Some technical error is there. Kindly bear with us. we can do till the time this is solved, we can start with some question answers people has. Mr. Muhammad Siddiqui, are you there? I can see the panelists in the attendees. You had a question. Mr. Muhammad Siddiqui.
Mr. Majumdar, your audio is very much blur. Your audio is not coming clear.
Hello, can you hear me now?
No, it's still not clear. Yes. Hello.
Yes, hello.
Now you are clear.
Yeah. Mr. Debanjan Chakraborty, he cannot hear us now. So we have some queries. Now, Muhammad Siddiqui had a question. Muhammad Siddiqui, are you there?
Hello.
Yeah, Muhammad Siddiqui. Mr. Muhammad Siddiqui, are you there? Debanjan Chakraborty, you are there back.
Yes,
sir.
I am there.
Yeah. Please restart your this one. Resume your presentation.
Please give me the link to share the slides. I think I have not given the permission to share my slides.
Debu.
Yeah,
Yes,
I am
now
just again giving him the permission. Sir, you can right now share your presentation.
Okay. Yes, can you? Everyone is. Can everyone see these slides of mine?
Yeah, we can see.
Okay. So sorry, it was a technical interruption. So now I'm coming back to the legislative structure of trademarks in India. The Indian law of trademark is enshrined in Trademark Act 1999, which came into effect in 2003. The old Trade and Merchandise Act 1958 was repealed at the same time. The Trademark Rules 2002 provides administrative and procedural aspect of trademark registration. The fourth schedule of Trademark Rules 2002 provides a comprehensive classification of the different types of trademark associated with different goods and services that can be registered in India. Recently, the new rules, 2017 rules have also been implemented. Important provisions of trademark laws. Now you can also, services can also be part of the trademark. Goods and services were extended up to 45 international categories. Registration of trademarks were extended up to 10 years. Special protection were given to well-known trademarks. Protection across goods or services if the brand name is reputed. The trademarks that can be registered are product trademarks are those that are affixed to the identify goods. Certification trademarks, the certifies nature and origin of the goods or services to which it has been applied by the proprietor. Example, ISO mark and ISI mark. Collective trademarks are registered in the name of group, association or other organization for the use of member of the groups in the commercial activities to indicate their membership of the group. What are the legal requirements for registration? The legal requirements to register a trademark under registration are: the selected mark should be capable of being represented graphically, that is in the form of paper. Anything that you can actually represent in a piece of paper can be registered. It should be capable of distinguishing the goods or services of one undertaking from those of others. It should be used or proposed to be used mark in relation to goods or services for the purpose of indicating or so as to indicate the connection in the course of trade between the goods and services, and some persons have the right to use the mark with or without identity of that person. Who can make the application? any person who claims to be proprietor of a trademark used or proposed to be used by him for goods as well as services. In case of company about to be formed, anyone may apply for a trademark registration in this name of a subsequent assignment of the registration in company's favor. What are the benefits? The registration of a trademark confers the owner upon the exclusive right to use a registered trademark and indicates so as by using R in relation to the goods or services in respect which the mark is registered and seek the relief of infringement in appropriate courts in the country. Duration of registration in country. The terms of registration of a trademark is 10 years, which may be renewed for a further period of 10 years on payment of prescribed renewal fees. However, non-users of registered trademark for a continuous period of 5 years is a valid ground for cancellation of registration of such trademark at the behest of a aggrieved party. This is a brief administrative structure. What we have offices in Mumbai, Calcutta, Delhi, Chennai, and Ahmedabad. GI has a registry in Chennai only, and Patent Information System has an office in Nagpur, NIPL. This is a brief jurisdiction what we have. We have vast jurisdiction of 14 states. The brief procedure what we follow is simple. Whenever we get a new application, we move it for process it through examination. If we are satisfied, we'll then publish the mark. If there is an examination, we'll send it to for hearing, show cause hearing. If it is okay or passed in the show cause hearing, then again it will publish for the mark. During the publication period, any person can oppose the said trademark, and thereafter the said time period of opposition, the marks get registration. Nowadays, most of the applications we are getting, more than 70% of our filings are online. This is our website ipindia.gov.in and ipindia.nic.in. Anyone who claims to be a proprietor can just log in the website and make a user ID and then file online. This is how briefly how the website looks like. Anyone can do public search in the website by just looking, clicking the link public search, so that he does not unintentionally copy any other's mark. This is how the public search website link page shows. You can search any word, put in the class, and then the prescribed marks relating to your search will be shown. These are the forms. In the other method of filing is offline mode, in which you can just take a printout of the application form, fill it, and then submit it in our office by with demand draft. This is how the registration certificate looks like, which will be sent to you on email, on the registered email ID. The briefly TMA forms which are actually there. Previously, there were various mini forms which were there. Now only 8 forms are there. TMA for all new applications, O for oppositions, R for renewal, P for post-registration amendment, U for registered users, C for NOC copyright applications, M for pre-registration amendments, TMG for registration of trademark agents. Infringement of trademark. What actually infringement is? An act constitutes infringement if affixes registered trademark to goods or services. Suppose if you use anyone's trademark and in your own in your goods, then you are actually committing a crime of infringement. Offer sales, stock, supplied goods and services under registered trademark, import or export under registered trademark, use of registered trademark on business paper or advertisement. What are the actions? A suit can be filed in a district court having jurisdiction. A suit can be additional district judge in High Court of Delhi, Mumbai, Calcutta, and Chennai, which have original jurisdiction. You have two options. You can go to district court, or you can file in High Court having original jurisdictions. What are the relief you can get in courts? Mandatory injunction restraining defendants from using the mark. You can get damages and cost, surrender of infringed goods, surrender of label, bills, hoarding, negatives, positive, pamphlets, brochures, anything. Criminal penalty is also there. The penalty for selling or providing services using a false trademark is minimum of 6 months and maximum of 3 years, and with fine not less than 50,000, but which may extend to rupees 2 lakhs. When you can, the word TM symbol you can use as soon as anyone files their trademark application, and the symbol R, it can be used only when the mark is registered and you get the registration certificate. Thank you. Any questions? If you have anything, please just let me know. I'll be there.
Thank you, sir. Thank you, Devan Chakraborty, sir.
Thank you.
So we now come to towards the question and answer session. So I was seeing a query from. Hello, am I audible? Siddharth, am I audible?
Yes, you are audible.
Yes.
Yeah. So now
Yes.
we are in the question answer session. We had somebody, Mr. Muhammad Siddiqui.
Okay.
Please unmute yourself, and you had a question that is it necessary to file through a patent attorney, or we can file it ourselves? Mr. Muhammad Siddiqui, you are there. Would you like to ask by yourself?
Yes, sir, I'm there.
Yeah, please ask your question. We can hear you.
No, I'm a researcher and I have some work done on my product. I just wanted to know, is it necessary to file as an SME?
Which institution are you from?
I'm in Usmania University. I'm a research scholar there.
Okay, please, yeah. Okay.
Yeah, so can I file as an individual, or is it necessary to file as an SME?
Then filing of what?
A patent, basically.
Sundar
I'll
Bhattacharya,
answer
sir?
you.
Yeah, Deepanjan Chakraborty, sir, please.
You can file on an individual basis. There is no bar. You have to be an SME or an agent to file it. On an individual basis, you can file, but there are many intricacies in it. Better understand it and then file it.
Is it necessary for me to file through an agent, or can I can
not
directly
necessary.
go?
It's not absolutely necessary. You can very well file it on your own, but just do a little bit of research on whatever you are filing, and then file it.
Yeah,
You
that
can
I
do it on
understand. I understand that. You know, similar patent search, you mean?
Yes.
Yeah, that I understand. And then what time frame are we speaking about? I heard 2 years is the time frame.
There is no time frame. You just file it, and you will be getting it very.
Thank you, sir. Thank you.
Yeah, Chakraborty, sir, I just wanted to ask, like, since filing of a patent and all this very technical, isn't the assistance of an attorney not required in sometimes?
Yes, assistance is may be required. We cannot suggest you. You might be competent enough doing it yourself. But in trademark applications, attending hearings, in show cause hearings, when we have cases. So if you think you are capable enough or you have competency in yourself, then you can very well do it. But it's preferably if you go through an agent or an attorney, it will ease your life.
Okay. Anybody else who wants to ask something? I see some participants here. Please feel free to ask anything you'd like to ask. This is regarding the trademark, patent. Or even if you are not aware what is trademark, why do we need to do that? Those kind of questions also can come in. So fine, I think currently nobody is interested to ask so many questions. Fine, we have got please, we'd like to inform to you that we have, there's an intellectual property facilitation center now at Indian Chamber of Commerce Northeast office. This center is installed, set up with support from Ministry of MSME, Government of India. And we are there to support you in registration of all kinds of IPs, trademarks, patents, industrial designs, geographical indications, copyright, all forms of things can be done from our center. This is the only center in the entire northeastern region. So we have our office in Ganeshguri. So please feel free to come to visit our office or even call us. And if you have any inquiries or any requirements for registration of any of your IP tools. So thank you very much. Thank you very much.
Can I add something here?
Yeah, please.
Well, I would like to inform to all our participants, mainly the visitors who are here, that this IPFC center do not charge anything for consultation for any kind of IP related matters, whether it is a non-judicial registration related to trademark, copyright or patent, or it may be a consultation relating to your judicial queries, where you may have some litigations where you are already a registered IP holder, where you want to go for some litigations and all. We do not charge any consultation for this. Please feel free to visit our center here so that we will be able to give you some more support. So that is the main purpose of setting up this IPFC center here in Guwahati. Thank you very much.
Yeah, thank you, Mr. Bakshi. So thank you to the panelists for being there, for giving us your precious time. Thank you to the attendees for a patient hearing. We will be conducting such kind of awareness webinars and seminars in the days to come. So thank you so much. Thank you all. We now come to the end of the meeting.